The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning, everyone. The next case is State v. Goins, and we'll hear from the appellant.
Good morning, Mr. Chief Justice, and may it please the court. Nick Brode for the state. I'd like to reserve 5 minutes for rebuttal. When the state introduces overwhelming evidence of a defendant's guilt, the defendant generally cannot carry his burden to show prejudice, entitling him to a new trial as a result of a prosecutor's closing argument. If ever there were a case to demonstrate the wisdom of that well-settled rule, this is it. The state here introduced a mountain of evidence that the defendant planned and attempted to execute an effort to evade arrest at all costs, including if it meant attempting to kill a law enforcement officer in the process. The evidence included, for example, a videotape recording of the defendant getting into a shootout with a police officer in the narrow third-floor hallway of a hotel building full of people. It included testimony from the defendant's own grandmother and uncle that shortly before the shootout, the defendant bought what he called, quote, cop killer bullets, unquote, that could pierce a bulletproof vest. And it included testimony from eyewitnesses who heard the defendant yell profanity about the police immediately before the shootout and then tried to leave the scene after it was over. Despite all of this evidence, the Court of Appeals below held that the defendant was entitled to a new trial. In reaching that conclusion, the Court of Appeals erred by focusing its prejudice analysis exclusively on the content of the statements the prosecutor made during her closing argument, and by ignoring the overwhelming and unusually compelling evidence of the defendant's guilt. The decision below should therefore be reversed. This case, just like the case the court finished hearing, involves a prosecutor's closing argument, and I think everyone generally agrees on the high-level legal framework for analyzing closing arguments like this one. It takes place in a two-step process. At step one, a court asks whether the prosecutor's statements were improper, and at step two, a court asks whether the improper statements caused prejudice. This case involves step two of the analysis, whether the improper statements caused prejudice. I think everyone also agrees that the defense attorney in this case did not lodge a contemporaneous objection to these statements during the trial. There was no objection when the prosecutor gave her closing argument. And so this court applies the gross impropriety test in that kind of a situation. As in the last case, the standard for a gross impropriety is a burdensome one. It requires a defendant to show a fundamental error, an error that affects the fundamental fairness of the trial. In this type of situation, I think fundamental fairness has a specific meaning. You're looking for an error that caused the jury to shift its focus from finding facts and objectively applying law to fact to a jury that was inflamed by prejudice or passion or bias. And in order to figure out whether that type of prejudice has occurred in any given case, I think you're looking at a number of different factors, and that was the error of the Court of Appeals here. I think the error of the Court of Appeals here is that it applied a per se rule when this area of analysis generally relies on a multi-factor approach. The factors that a court typically looks to decide whether a closing argument caused prejudice include the content of the statements themselves, which was the sole focus of the decision below. The decision below looked only at the prosecutor's statements that she made during the closing argument. But it also considers other factors, including the overall context in which the statements took place, the frequency of the comments, and the strength of the state's evidence. And it also includes an analysis of whether the state admitted overwhelming evidence of the defendant's guilt. When the state has introduced overwhelming evidence of a defendant's guilt, the defendant generally cannot carry his burden to show prejudice. And I think that core principle resolves this case.
Despite the quantity of the evidence that you state is overwhelming, these misstatements here by the prosecutor go to a fundamental right of a defendant to be able to plead not guilty and have a jury to determine his or her fate. Why doesn't our statement in Larry, that case that we decided as a court, operate to establish that the state's improper argument constitutes a grossly improper argument where the state specifically references a defendant's failure to plead guilty?
Your Honor, I think Larry is different for the following key reason. In Larry, there was an objection during the trial. The defense attorney in Larry objected to the criticism that was leveled against the defendant in that case for his failure to plead guilty. And because there was an objection at trial, in Larry, this court put the burden on the state to show that the error was harmless beyond a reasonable doubt.
Is that distinction sufficient to differentiate this case from Larry in light of such a fundamental opportunity for a defendant to plead not guilty if he or she chooses?
Your Honor, I do think it is sufficient to distinguish this case from Larry, because I think the burden on the state in a harmless beyond a reasonable doubt case is very, very different from the burden that is on the defendant, not the state, the defendant, in a gross impropriety case. There's no question that a defendant has a constitutional right to plead not guilty and a related right not to be criticized by the state for exercising that choice. But I think the cases show that when there is not an objection during the trial, your review is limited to the gross impropriety test, which puts the burden not on the state but on the defendant to show not just any error, but a grossly improper error, an error that goes to the fundamental fairness of the trial. And I think that's why Larry is so different from this case. Larry was the only decision from this court that the Court of Appeals relied on below. And I think given that there was an objection during the trial in Larry, it just really doesn't have anything to say about this case. I think another point that I would add on Larry is that even though the defense attorney in that case did lodge an objection during the trial, this court still affirmed because there was overwhelming evidence overwhelming evidence that had been admitted by the state at trial against the defendant. So I think Larry is different for those two key reasons. It's different because there was an objection in Larry and there was not an objection here. And it's also different because in this case, the Court of Appeals ignored the principle that Larry recognizes, that when the state introduces overwhelming evidence against a defendant, the defendant generally cannot show prejudice. There's no doubt as well that the right to a jury trial is an important right. It's a fundamental right, as Your Honor mentioned. But I think Larry shows that even though it is a fundamental right, there are circumstances when a prosecutor's decision to criticize a defendant for exercising that right will not automatically result in a new trial. And that was the error of the Court of Appeals here, was to sort of short circuit the traditional prejudice analysis that this court applies when a defendant does not make an objection during a closing argument of a trial.
But why would a prejudice analysis even be required if you've got the state's argument being conceded to be improper and the state is castigating the defendant for standing on his rights in this case?
Your Honor, I think this court's recent decision in State against Huey might be a helpful one in answering your question. I think Huey makes clear that when a defendant does not object during a closing argument, it's the defendant that has the burden to show prejudice. And in order to carry that burden, you have to look not just at the content of the statements during the closing argument, but also at their frequency and at the strength of the state's case. And that was the error that the Court of Appeals made here. Is it just looked at the statements and nothing else. I mean, just to put a finer point on it, the jury here sat over the course of 3 days. It heard from 12 witnesses. It examined 41 exhibits. And yet the Court of Appeals undid the work of the jury, undid the work of the trial judge, based on 2 paragraphs of the closing argument here. I mean, there's no question there was a reference by the prosecutor about the defendant's failure to plead guilty, but that reference took place in 2 paragraphs over the course of a roughly 26-page closing argument. That type of approach, that type of abbreviated prejudice analysis, I think is directly contrary to this court's decision in Huey. I mean, I think Huey says point blank that in conducting a prejudice analysis, a court has to look beyond the content of the statements themselves and also look to the strength of the state's case. I think if you look at the evidence that the state introduced against the defendant at trial, it really does show overwhelming and unusually compelling evidence that the defendant had the requisite intent to be convicted of attempted first-degree murder.
Is Huey dispositive? Is Huey dispositive here as the dissent sees it?
Yes, Your Honor. I think Huey is dispositive. I think Huey is my best case. I think that the statement in particular on page 185 of Huey, that a prejudice analysis cannot solely focus on the content of a prosecutor's statements during closing argument, is directly contrary to what the Court of Appeals below held. I mean, the Court of Appeals admitted in its opinion that it was only going to look at the content of the statements. And I think the dissent citation to Huey was absolutely correct, because Huey makes clear that that type of an approach that looks only at the content of the statements is not a complete prejudice analysis.
But isn't Huey distinct from this case because, as an initial matter, the court in Huey did not find the statement to be grossly improper, and whereas here, assuming we do find it grossly improper, we're in a different universe.
Your Honor, I think I read Huey maybe a little bit differently. I think I read Huey as conducting a prejudice analysis that incorporates an understanding of at least some of those statements as improper. I mean, the statements in Huey were that the defendant was a liar, that the defendant was in cahoots with his attorney and with an expert witness, and that they had all sort of conspired together to lie about some of the facts of the case. And the court explained that was in fact improper, and it was not just a kind of a limited statement like the statement we had here, but it was the whole theme of the closing argument in Huey was that the defendant was a liar, his attorney was a liar, the expert was a liar, and the court analyzed the prejudice that resulted from that without just focusing on the question of the content of the statements themselves.
And so I want to ask you your view of the additional statements in Huey about the challenges where the prejudice analysis essentially says, okay, a prosecutor can say something grossly improper, but there's no consequences that flow, and the majority opinion talks about, we have repeatedly said these things are grossly improper, and prosecutors keep saying them. And it seems, doesn't that result in a rule where the constraints only exist if the evidence is close? And how, is that really a fair rule?
Your Honor, I think you're always looking at the entire case. So I think you're always looking at the content of the statements, the strength of the case, and the frequency with which the statements were made. So I could spin out a hypothetical where, despite a very strong case, you might nonetheless find prejudice because the statements were very bad and they were said often, or they were a core part of the closing argument. I think that's the benefit of the kind of flexible prejudice analysis that the court explained in Huey, that takes into account sort of all of the factors in which the closing argument took place, and is contrary to the type of analysis, the type of per se approach that the Court of Appeals took here. I don't think that the prejudice analysis in these cases is a blank check to the state to say whatever it wants during a closing argument. I think the prejudice analysis is an important, critical legal tool that the court uses to decide whether the defendant has received a fair trial. And in reaching that conclusion, you have to look at the strength of the case, because you're trying to figure out whether there was some likelihood that the improper statements actually mattered, actually influenced the jury verdict. And if you're only looking at the content of the statements themselves and you're not considering the broader context in which they took place, I don't think you can reach a reliable decision about whether, in fact, the jury's focus shifted from the role of a fact finder, which is what we want in every single case, to a jury that was inflamed by prejudice or passion or bias in a way that would have caused the trial to be fundamentally unfair.
I wanted to ask a follow-up question about Huey. As I understand Huey, and correct me if I'm wrong, is that the court felt that, or determined that the argument was not grossly improper, and in fact, it was possibly supported by the evidence, that they criticized the prosecutor for calling the defendant names, calling him a liar, but still said that the evidence arguably supported the argument that he was being untruthful. So it sounds like not only was it not grossly improper, it might not have been totally improper, that you just can't call the defendant names. Am I reading too much into that?
No, Your Honor. I mean, I think I generally agree with that reading of Huey. I mean, I suppose I would point the court again to page 185 of that case, where I think the court is conducting a prejudice analysis on the assumption that the statements were some degree of improper. I mean, Your Honor is correct that there was an evidentiary basis in Huey for some of the statements, but I think the court's analysis proceeds on the assumption that the statements were improper, and that therefore the court had to do some kind of prejudice analysis that involved looking at the record and the content of the record before it could decide whether the defendant in that case should have received a new trial.
Well, let me ask another question about that. How would you distinguish the type of prejudice analysis that you would do in a case where the closing argument is pretty clearly grossly improper, versus at the other end of the spectrum where it might not be totally improper at all? How do you differentiate the kind of prejudice analysis that you do?
Your Honor, I think this court's recent decision in Copley makes a comment that prejudice isn't a quantifiable commodity. And I think that maybe goes to your question. I think it's going to be a case-by-case analysis. And I think when the statements are particularly bad, I mean, the worse the statements are, I think you're going to need something else to assure the court that the trial was still nonetheless fundamentally fair. So it may be that when statements are more egregious, you're looking for stronger evidence against the defendant, or you're looking for statements that maybe were more isolated to try to blunt the force of the prejudice. You might also look at the jury instructions or the conduct of the jury. I mean, I think that's maybe another facet of Huey that might be helpful here. The jury in Huey made a specific request to review some of the exhibits that the state had introduced at the trial, and the court explained that request was a good piece of evidence to show that the jury was discharging its responsibilities seriously, that it was taking seriously its obligation to find facts and make a reasoned decision rather than relying on passion or prejudice or bias. And the jury here did that. If you look at page 33 of the record, the jury made a request to review the video footage of the shootout between the defendant and the police officer in this case. And I think that shows that the jury was acting as a fact finder, was taking its obligation to find facts and apply the law seriously, rather than being inflamed by an improper argument by the prosecutor during her closing. All of this, I think, is to say that this is a flexible analysis, and that's why the decision below was incorrect. I don't see any support in this court's cases for the kind of per se approach that the Court of Appeals took below. I think you can imagine some difficult hypotheticals where you're trying to balance these different factors, where you're trying to balance the strength of the state's case against the severity of the improper statements. But I don't think that's this case. I think the decision below is directly contrary to Huey, and could be reversed on that basis alone. I mean, the defendant raised 3 other arguments in the Court of Appeals. The Court of Appeals did not reach any of those arguments. It reached only this one argument about an improper closing. And the other 3 arguments that the defendant made below also rely on a prejudice analysis. And so I think if the court were to agree with the state's position here that the approach of the Court of Appeals was incorrect, was contrary to the approach set out in Huey, one way of resolving the case perhaps could be to remand to the Court of Appeals to conduct the prejudice analysis in the first instance. I think, as we set out in our brief, if the court is inclined to reach the prejudice issue and engage in that analysis, I really do think the evidence here was overwhelming and uniquely compelling. The defendant was on probation for another felony. His probation officer testified at trial that he had informed the defendant that if he did not comply with the terms of his probation, that he could potentially be arrested. There was a warrant put out for his arrest. He, at a family gathering in Easter of 2017, told his grandmother and his uncle that he had bought bullets that could pierce a bulletproof vest. He told his uncle that the bullets were what he called cop killer bullets. The bullets that were found at the scene were in fact bullets that are known on the street as cop killers. And the defendant executed that plan here, and there's a videotape of the defendant doing that. The video exhibits are on file with the court. They're exhibits 21 and 22. Exhibit 22 is a slow motion video that I think is maybe a little bit easier to see, but the video clearly shows the defendant running down the hallway of a hotel building with, I mean, there were people in the hotel, people living in the hotel at that time, running down the hallway, stopping, turning around, squaring up, facing the officer. And then, the eyewitness testimony at trial was that the defendant at that time fired his gun at the officer, and the officer returned fire. There was testimony that immediately before the shootout, the defendant yelled profanity about the police, and that he attempted to leave the scene after the shootout took place. I think the only argument that the defendant has made to try to carry his burden of prejudice is that, well, maybe the officer was the first to fire the gun, and that if the officer had been the first to fire the gun, there might have been adequate provocation for the defendant to return fire. I think if you look at the eyewitness testimony just does not support that argument in my view. And I point the court to page 87 of the transcript, where the officer who was involved in this shootout testified that the defendant fired the first shots. And then I would also point the court to page 138 to 39 of the transcript, where the eyewitness to the shooting testified that the officer was returning fire after the defendant had fired the first shots. Even if the court is not entirely clear about the sequence of the shooting on the video or the eyewitness testimony, I think the jury's request at page 33 of the record to review the video for itself is good evidence that the jury was, as I said, discharging its fact-finding responsibilities in a serious manner, and not out of prejudice or passion or bias as a result of the prosecutor's improper closing argument. Unless there are further questions, I'll reserve the remainder of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
Good morning. May it please the court, Joseph Lattimore on behalf of Brandon Goins. It has been recognized that a specific intent of a defendant is something that lends itself to each by a jury. Defendants every day in our courtrooms build a defense upon the concept that there is reasonable doubt about specific intent. Unsurprisingly, in this case, Mr. Goins crafted a defense that there was reasonable doubt as to whether he had a specific intent to kill Investigator Hinton at the moment that he fired those shots in the hallway of the hotel. In this case, everyone understands that. As defense counsel stated in his closing, you know what the issue in this case is, and I'm going to boil it down to really just talking about one element of one of the charges. He then refers to premeditation and deliberation, and that's at page 367 of the record. So with the case in this posture, the prosecutor went on the offensive and attacked Mr. Goins for selecting that legitimate approach to the defense, an approach that is recognized in our Constitution. The state concedes throughout its brief that this was improper on several levels. And we further contend that when you conduct the prejudice analysis that our cases provide, and you look at the factors that the cases discuss, that you can determine that there was the requisite level of prejudice here to give Mr. Goins a new trial. We must show that the remarks were of such a magnitude that their inclusion prejudiced Mr. Goins and thus should have been excluded by the trial court. In other words, that they infected the trial and violated due process. And this involves examining whether the state's evidence on the live issue of specific intent was overwhelming, as the state contends, whether the prosecutor's comments were an evidence-based response, or whether it was an appeal to the jurors' emotions and to try to take them away from their function of resolving disputes, and whether the trial court addressed the improper comments through proper instruction. I want to now discuss the Huey case, which has gotten a lot of attention so far. The state suggests that the fact that the jurors wanted to review the evidence again shows that that their decision was based on the evidence and not on prejudice or passion in relying upon the prosecutor's improper arguments. But the analysis in Huey goes a little bit further than that. It's not just that the jurors asked to see the evidence again. If you dig a little bit deeper into Huey, you'll see that the jury came back with a verdict on a lesser included offense. And that led the court to determine that they must have indeed listened to the evidence in the case, including the defense expert who had been robustly criticized by the prosecutor in the case. So what they said in the conclusion is that if the prosecutor's statements had destroyed all credibility of the scene, there would be no testimony to support a finding of voluntary manslaughter. However, the jury convicted defendant of voluntary manslaughter, indicating they found he acted in imperfect self-defense. So that's an example of where this court can hang its hat on something in the record which shows that the jury, in fact, listened to the evidence in the case and not the improper argument of the prosecutor. I think
do you agree? Are you in agreement with the state that Huey applies to this case?
I am in agreement with the state that Huey's analysis does apply. Your Honor had asked some questions before about the constitutional nature of the violation, and for decades, this court was reviewing constitutional-based closing error arguments that were not preserved under what a slightly different standard. But then Phillips came along, and it appears that under Phillips and the cases that follow, including Huey and Tart and the DeGraffenreid decision that the dissent relied upon in making, that we now have to do a statutory prejudice analysis because constitutional violations, apparently according to Phillips, cannot be reviewed on their own as a constitutional claim. But our position is that following Phillips and DeGraffenreid and Huey and Tart, the nature of this improper comment is that it violates not only well-established constitutional principles under the Sixth Amendment, but it also violates the statutory provisions governing closing arguments.
Because you're invoking the Constitution, counsel, coupled with the statutory recognition, is it your position that this improper statement is prejudicial on its face, or that it is grossly improper under a prejudicial analysis?
It is grossly improper under the prejudicial analysis that we see following Phillips. Ask for no different treatment than the defendants in Phillips, Tart, Huey, and DeGraffenreid received. We're not asking for any different treatment, any different standard of review than they received. And if we look at these individual factors that drive the decision as to whether or not there's prejudice, we've got to begin with whether or not the state's evidence was overwhelming or untested.
Is it your contention that the Court of Appeals did conduct a prejudicial analysis in this case?
What I'll say about the Court of Appeals decision is that it appears to be thinner than I would have liked it to be. However, I disagree with the state on their contention that the court somehow applied the wrong standard. I think it's pretty clear that when in the beginning of their opinion, the majority identifies the proper standard for an unpreserved closing argument error.
But even understanding that, though, again, going back to my question about the prejudicial analysis, which is where you're comfortable being situated, was there a prejudicial analysis conducted by the COA in this case?
They didn't address,
in its opinion.
They didn't explicitly address these specific factors that I'm going to address today in my argument.
Mr. Lattimore,
I'm sorry.
Mr. Lattimore, what would be one of the things that your colleague suggested that we might do if we felt that the Court of Appeals had not conducted an adequate prejudice analysis was to reverse the decision, state that there was, such an analysis was required and then remand the case to the Court of Appeals for them to conduct a prejudice inquiry in the first instance. What's your reaction to that suggestion?
My reaction to that suggestion is that in the interest of judicial economy, I don't think that's the proper approach here. Both parties have briefed this issue of prejudice thoroughly, and this court has the ability to conduct the more thorough prejudice analysis that arguably the Court of Appeals failed to do. I think if that analysis is properly conducted by this court, looking at all the factors, that this court will majority's decision.
Well, I cut you off as you were getting ready to tell me why it was prejudicial. So let's, if you would, go ahead and
Very good.
continue to say and tell me why this should be deemed prejudicial in this case.
Thank you, Your Honor. The reason why this is prejudicial in this case is looking at all of the factors that inform this decision. That is, whether the state's evidence is overwhelming on this issue of specific intent, the specific context of the argument by the prosecutor, and whether there were curative instructions given by the trial court. Looking at all of those factors in this case, our position is that Mr. Goins was prejudiced to a degree that a new trial is required. Just turning to the state's contention that the evidence was overwhelming, they go on to a disputed element at trial was specific intent, that the evidence was uncontroverted. First, any attempt to argue that there was a master to kill officers formed in the weeks before the incident should be rejected. Mr. Goins' statements to his family members are susceptible to different meanings, as is any language that's used in our society. And intent is subject to change. That's human nature. We have to look at the short period of time in the hotel in this case. That's what this boils down to. The time that transpired in the hotel hallway, and we have to determine whether he had the requisite to kill with deliberation. In those moments at the hotel, there is a dispute whether Mr. Goins had the requisite specific intent to kill Investigator Hinton. Although he had a chance to do so, Mr. Goins did not fire.
What is the evidence that tends to suggest that he did not act with specific intent, with premeditation, deliberation, and specific intent to kill? What specific pieces of evidence go to that?
For instance, Mr. Goins did not fire his gun when he had the opportunity to do so at Investigator Hinton at the doorway that led to the entrance of the hotel. The first confrontation between the two of them. Although he had an opportunity to do so, if he had a master plan to kill officers, he did not fire the weapon. And although he had a chance to do so, Mr. Goins did not fire his gun at Investigator Hinton when Investigator Hinton reached him at the top of the stairwell and pinned him in the door, apparently very close to Investigator Hinton's face. So instances where he could have acted according to this master plan that the state contends he had, but he didn't do so. There's also a dispute created by the video footage, as the state suggested I was arguing. And this can be seen at the 16th hour, 20th minute, 47 seconds, 48 seconds, and 49 seconds of Exhibit 22, which is the slow motion video. You can see video appears to be, and what can be interpreted by a jury as 4 distinct shots by Mr. Goins after he's already on the floor and he has been fired upon. And defense counsel buttressed this through his cross-examination of investigator Hinton and the civilian Shannon Arnett. Investigator Hinton thought he may have struck Mr. Goins at the moment he was falling. And that's at page 128 of his testimony. And Mr. Arnett, the civilian witness, at first said the blast from Mr. Goins' gun came when he was on the floor. And in a follow-up question by defense counsel, he clarified it appeared to be while Mr. Goins was falling. So when you consider what out on cross-examination with what can be found from a careful viewing of the video evidence, it can be interpreted that Mr. Goins was first hit by gunfire and then started falling. He then responded by firing his weapon. There is a dispute based on all of this evidence, who shot first and whether or not he had the specific intent to kill in that situation. That supports a reasonable doubt on the deliberation element of attempted first-degree murder. It's also important in this analysis to look at the context of the prosecutor's remarks. The comments were not made as part of a rebuttal of certain evidence or as part of an analysis of specific evidence in the case. Thus, the prosecutor's statements here did not serve to sharpen and clarify the issues for the jurors as the triers of fact. That's a quote from the Tart decision at page 85 and page 845. In that case, looking at the context of the remarks, the prosecutor's comments about defendant's mental illness showing that he had specific intent to kill many people over a 20-year period of time were not grossly improper, because it was an evidence-based rebuttal of defendant's staunchest position that his mental illness precluded him from forming the specific intent to kill. But the prosecutor in this case pivoted at the moment that these improper remarks were made. She had been discussing evidence earlier on in her closing argument. There's no question about that. There was some discussion of the evidence. However, she pivots at this and she ridicules Mr. Goins' decision to put the state to their burden in a trial on one particular of the most serious charge. And so the prosecutor diminished the importance of the jury's function in resolving the lie of specific intent.
Counsel, if I could, Counsel, I
Yeah.
apologize. If I could, you mentioned
okay.
the jury's function. Your friend on the other side argues that to the extent there was prejudice, the trial court's instructions cured any such prejudice. If we were to, as you suggest, decide the case without remanding to the Court of Appeals, what should we make of the jury instruction in this case?
That they had no effect whatsoever in curing this grossly improper. The state contends that less than 30 minutes after the closing argument, the trial court instructed the jury that the prosecutor's earlier statement, Goins' decision to plead not guilty, be taken as evidence of his guilt. The instruction also underscored that when a defendant pleads not guilty, the defendant is not required to prove the defendant's innocence. That is the proposition on which this to argue that the prejudice was cured. But that instructs the jury that the fact that it has no evidence of his guilt. It also addresses the distinct concept of the state's burden of proof under the Constitution. This was not an attempt by the court to specifically address the improper argument of the prosecutor. Therefore, this does not cure that grossly improper argument that was the prosecutor and that the state acknowledges was wrong. It's all about Brandon Goins' civic intent in a chaotically developing situation inside a hotel hallway. Mr. Goins' defense hinged on the jury's careful consideration of this issue and their holding the state to its constitutionally imposed burden. But the prosecutor made improper comments designed to get the jury to not perform their function, resolving the dispute. She conveyed to the jury that this was not a legitimate exercise, but rather just a stunt by Mr. Goins because of the amount of time that he was facing. This was grossly improper, and factors that I've thoroughly discussed in the argument today, Mr. Goins should receive a new trial. And if there are no further questions, I would rest on my brief.
Thank you, counsel. Rebuttal.
Thank you.
Thank you, Mr. Chief Justice. I'd like to make four points briefly. First, I agree with my colleague that the Court of Appeals' prejudice analysis in this case is thin. I think it's so thin as to be virtually non-existent. The Court of Appeals did not follow this court's clear direction in Huey that a prejudice analysis cannot rest solely on the content of a prosecutor's improper statements and must consider the broader context in which those statements are made, including the strength of the state's case. And the Court of Appeals did not apply that kind of prejudice analysis here. I think that is a sufficient basis on which this court could reverse and remand to the Court of Appeals without getting into any of the other questions in this case about how the prejudice analysis might play out on these specific facts. If the court is inclined to conduct the prejudice analysis here, I would make three other related points. The first is that I don't think the testimony from the defendant's family members, his grandmother and uncle, who testified on the state's behalf in this case, is susceptible to multiple interpretations. The testimony, I think, is very clear that the defendant boasted to his grandmother and his uncle in Easter of 2017 about having what he called cop killer bullets that could pierce a bulletproof vest, and that he was prepared to either kill himself or have the police kill him before he went back to jail. And I think what happened in that hotel hallway on the day of the crime is entirely consistent with that testimony and with the plan that the defendant explained to his family members shortly before the shootout took place. My third point goes to the jury instructions that Justice Berger was discussing with my colleague. I want to echo something that my colleague Mr. Wood told you in the last argument, which is that I think the jury instructions are at least a data point. They're at least something to consider. It's at least worth thinking about the fact that the jury here was instructed that just because the defendant has been charged with a crime does not mean that he was guilty of the crime. And so if there...
Can I just ask you about that? Isn't that a little different from being instructed that just because he has exercised his right to trial, you shouldn't conclude that he's someone who doesn't take responsibility for his actions? Aren't those two different things?
Your Honor, I would concede that it is not a one-to-one match. I would concede that. It is not a specific instruction that addresses in a very direct manner the statement that the prosecutor made. I think it's at least, as I said, a relevant data point to consider that the jury was made aware in these instructions that just because the defendant had been charged, it did not mean that he was necessarily guilty of the crime, and that the state had the burden to prove that the defendant was guilty beyond a reasonable doubt. I think that's at least a data point. It is not the core of my argument. The core of my argument is that the evidence here was overwhelming, but I think to the extent the court has any doubts about the strength of the evidence, I think the later jury instructions are at least a data point that the court can consider in the prejudice analysis.
And if I can just really quickly ask you on the point about remand and the judicial economy of doing so, isn't it true that there are additional issues that the Court of Appeals would have to address? So even if we found for the state on this issue of whether or not there was, if we found there was no prejudice, there's still other issues that the Court of Appeals would have to review.
Your Honor, that's correct. I mean, the other issues that the Court of Appeals will have to review also turn on a prejudice analysis, because the errors that the defendant has alleged in this case weren't preserved. So I think in that sense, it may actually be more efficient to remand for the Court of Appeals to do a prejudice analysis that will address all of the issues that the defendant raised below. But you know, I think that's a matter of the court's discretion. My respectful suggestion is that one potential way of resolving this case, if the court agrees with the state that the prejudice analysis here was not complete, would be to remand. But of course, the court could exercise its discretion to analyze the record here and the defendant's specific argument about prejudice from this statement. I think my last point, just briefly, is that there is no constitutional claim in this case that has been preserved. I wanted to make that very clear. I mean, there was no constitutional claim that was pressed in the trial court, and for that reason, the court is here reviewing only for a gross impropriety. The court is not here, like it was in Huey, reviewing a preserved constitutional objection, or sorry, in Larry. The court is not here reviewing a preserved constitutional objection. It's reviewing an unpreserved error, and that means the gross impropriety test applies. And for all the reasons I've stated, the court should reverse. Thank you.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 45 minutes. God save the state and this honorable court.